Thank you so much, Chairman, and I appreciate the opportunity to come here today. My name is Kimberly Thomas. I'm a law professor at the University of Michigan Law School and co-director of the law school's Juvenile Justice Clinic. What I want to do here today is focus my testimony on three things. I want to give you a brief overview of the Miller versus Alabama opinion. I want to also give you an overview of the Michigan laws that result in mandatory life without parole, just so everyone is on the same page about how we got to where we are today. And in conclusion, I'd like to give you a little sense of some of nationally what's been going on, and just a note on that. With that, just as an introduction, I think that many of you are probably parents and understand that there are distinct behaviors that are seen in adolescence, and that now we know from cognitive neuroscience that in fact youth's behavior youth increases their likelihood to engage in risky behavior, their inability to foresee and appreciate the consequences of their actions, and their susceptibility to the influence of others. These differences are biologically based, and research shows that even for youth who commit violent crimes as teens, that the vast majority, most of those young people will go on to become law-abiding citizens, that they will in fact mature and change. Those differences generally in youth behavior are the basis for a number of laws which we're all familiar with. We don't allow children under 18 to purchase cigarettes. We don't allow children to be emancipated from their parents. We don't allow them to drink alcohol. And we've also set up a completely different system, the juvenile justice system, for teens in Michigan under 17. These differences in youth have influenced the U.S. Supreme Court's understanding of adolescence and adolescent behavior. And really the bottom line is that the court has told us that youth are categorically different, and we need to think about them differently when we're looking at sentencing them than we do adults. In Miller versus Alabama, which is a decision from last year, the court held that juveniles could not mandatorily be sentenced to life without parole. That's the holding. To reach the holding, the court looked at two prior strands of case law. The first strand looks at whether sentences should be categorically banned based on a mismatch between the culpability of the offender and the punishment. And so the previous cases on this were Roper versus Simmons, which said that persons under 18 could not be given the death penalty under the Eighth Amendment. That was unconstitutional. The case after that was Graham versus Florida, which said that juveniles who did not commit a homicide offense could not be sentenced to life without parole categorically. Just categorically, they were not as culpable as the adults who committed those offenses, and that was not a permissible punishment. The second strand of cases looks at the court's ban on the mandatory imposition of the most severe punishment. This line of cases came from the court's death penalty case jurisprudence, which said that the death penalty cannot be mandatorily imposed. There has to be contextualized, nuanced, individualized decision-making when you're going to impose the most severe punishment. What the court held was that you need, in these cases, an individualized determination with mitigating information about the youth's chronological age, and also features such as immaturity, impetuosity, failure to appreciate risks and consequences, family and home environment, the circumstances of the offense, the possibility the youth would have been charged and convicted of a lesser crime if not for what the court called incompetencies associated with youth. And here there was information before the court, and I'm sure there will be before you today, that sometimes youth are offered plea bargains to a lesser crime. They don't take that. They don't appreciate the severity of what they're facing. Sometimes adult co-defendants are more savvy about the criminal justice system. That was the information before the court and what they're referring to there. And the court linked that these, and this is sort of, people call these the Miller factors, right? There's these list of things that the court said were mitigating for youth and should be considered when we're looking at youth that are facing the most severe punishment, and that they should be incorporated into legislation or a court's consideration of sentences. We're here today because our current legislative scheme does not comply with Miller versus Alabama. It mandatorily imposes the sentence of life without parole, and it doesn't take into account any of these individualized factors. How did we get here? What laws are implicated in our current system? There's no one law in Michigan that mandatorily creates life without parole for juveniles. There's a series of laws in different sections of the code, so it actually makes it sort of quite tricky to figure out. I'll first address how those who are 16 and under are convicted and charged with life and sentenced to life without parole, and then 17-year-olds. First-degree murder is mentioned. First-degree murder in Michigan includes both willful and premeditated murder, and also what's called felony murder, a killing that occurs during the perpetration of a felony. The sentence for first-degree murder is life. To be convicted for felony murder, the person need not have intended that a life be taken. So there's no intent to kill with felony murder. It requires the person create a high risk of harm and is assumed to appreciate that risk of harm. If an individual aids and abets, you've also heard that language already this morning. I'm sure you'll hear that more. Basically what that is the person somehow assists in the felony or the killing. The juvenile need not be the person who commits the killing, but could be the proverbial lookout, getaway driver, or assistant in the crime. Under our system of laws, that person is equally culpable of the first-degree murder. The second law that creates the life without parole is the statute that was examined in the Eastern District of Michigan case. And this is a statute in the parole code that bars the parole board from having jurisdiction over cases where people are convicted of first-degree murder. So how do juveniles, so that's for adults, right, for an adult. How do juveniles get into the adult system? That was a question that was asked, and it's not obvious. For 14, 15, and 16-year-olds who are going to be charged with first-degree murder, the adult court system automatically has jurisdiction over them. So there's a law that gives the adult court automatic jurisdiction. So you don't have to first go to the juvenile court and then transfer to adult court. They are directly filed in the adult court system. Once in adult court, there's also a separate statute that automatically makes the same sentence for adults applicable to juveniles. And so juveniles, if convicted, are automatically given life without parole. So for 14, 15, and 16-year-olds, it's filed in adult court. If the person's guilty, the sentence is automatically the same. And so there's no ability to distinguish between what the U.S. Supreme Court has said, the vast majority of juvenile offenders, and the rare offender for whom life without parole is justified. That wasn't always the case in Michigan. We've increased the ability to file juveniles in adult court. We've made the sentence the same as adults. That wasn't always true. But we did have a pretty limited option. Courts could only sentence juveniles as juveniles or as adults. And so the end of the juvenile court jurisdiction is 21. That's a pretty limited option given the facts of a lot of these cases. But that was the previous option in Michigan. For 17-year-olds, Michigan treats 17-year-olds as adults. So the U.S. Supreme Court has said that these decisions treating children different apply for persons under 18. In Michigan, 17-year-olds are automatically subject to the adult court system and not the juvenile court system, no matter whether it's shoplifting or murder. It's the whole range of offenses. We are in the vast minority here. 39 states treat 17-year-olds as juveniles. And so here we're a bit of an outlier. And there might be a slight trend away towards including 17-year-olds within the jurisdiction of the juvenile court. But it's one reason that we have so many cases. My understanding is that there are approximately 360, although I'm not going to quibble with the numbers, individuals in Michigan serving life without parole. This is the second highest number in the country. It's not accounted for by the number of young people in Michigan. It's not accounted for by the youth arrest rate. Instead, it really is accounted for by the series of laws that I've just described to you that take away discretion and that automatically put 17-year-olds and 14, 15, and 16-year-olds within the jurisdiction of the adult court system. In terms of other states, there are a handful of states like Michigan that have a particularly robust system of mandatory life without parole. Michigan, Pennsylvania, Louisiana, and Florida are the top 4. These 4 states account for more than half of the juveniles serving life without parole nationally. So the numbers that you see are not typical. It's really not. It's really a problem that we have, and a few other states are really facing in terms of the large numbers based on the way our laws are constructed. The U.S. Supreme Court noted this disparity in its decision. It noted that in jurisdictions where judges had discretion and they could choose life without parole or a lesser sentence, that these states account for a much smaller proportion of the juveniles serving life without parole. And where we really see the high numbers are in places where there's no alternatives, where judges are mandatorily imposing those. And so when faced with the choice, judges do and are capable of making distinctions between different offenders and different crimes. In the early 1990s, when some of our laws took place, we were sort of in an era nationally of getting tough on juvenile crime. That era has generally subsided in a variety of ways, which I'm happy to talk about. More specific to juvenile life without parole, states both before Miller and after Miller have eliminated it entirely as a way to either comply with Miller or as a way that they believe to make their system more equitable. So, states that you wouldn't think of as sort of particularly soft on crime, Wyoming, Texas, Colorado, they've all just eliminated life without parole as a way to correct their systems as they see it. Other states have eliminated life without parole for specific types of offenders, so they've eliminated it for felony murder, recently in North Carolina, Pennsylvania. And, one, I guess, thing to say is that you can look at the general trend toward responding. Many states have responded. I think you want to be cautious when you look at, and many other states have given a range, essentially. There's a term of years sentence that judges can make contextualized individual decisions based on. But you want to be cautious when you look at the numbers. It's hard to compare different systems. Some states have a good time, some states have different parole systems, and so you just want to be careful when you do that if that's something you're going to undertake. For example, Nebraska, I think their law says 40 years, but it really means 20. It's sort of, you just want to be careful when you're comparing other states' legislation. In sum, the U.S. Supreme Court decision in Miller versus Alabama requires us to treat youth differently for sentencing purposes and make individualized contextual decisions that include consideration of the mitigating factors that the court stated in the decision. I think that the bill that's in front of this body complies with that, and I'm happy to answer any questions.
Thank you very much. A brief question I've got, you answered one of them already. In your research in Michigan, and if you haven't done it, that's okay. Any idea of the 360 who are incarcerated? Have you done any research on how many of those were the result of ineffective assistance of counsel or the result of plea bargaining gone awry? Is there any light on that you can shed?
I don't have the numbers. I know that there might be some other people here today with good numbers on that. I do know that, anecdotally, there are certainly youth who were offered, 7 to 15 years for a second-degree murder who were, sort of the aider and abetter and turned that down and are now serving life. So there's certainly those cases out there, but other than anecdotes, I hesitate to give you numbers on that.
All right. Any other questions? Representative Robinson.
Would you happen to know what the recidivism is for murder?
Well, I don't have good numbers on youth recidivism for murder, and some of that would be tricky to figure out because for someone serving life without parole, we wouldn't, they wouldn't calculate recidivism rates like that. It's low, but an exact figure I can't give you.
Now, in terms of the 4 states that you mentioned, Pennsylvania,
Florida and Louisiana.
Yes. What is the philosophy is it just punitive sentencing from those 4 states?